Be ready. Start. Index Medical College, Hospital and Research Center and others have filed the appeal arising out of SLP number 179 of 2021 assailing the validity of the judgment dated 15th December 2020. Stop. LN Medical College, Hospital and Research Center has also challenged the said judgment of the High Court by asking permission to file SLP. Stop. People's College of Medical Sciences and Research Center filed a writ petition questioning the wires of Rule 12 as well. Stop. It was disposed of by the High Court of Madhya Pradesh, giving liberty to the petitioner therein to file an appropriate representation before the Directorate of Medical Education for redressal of its grievances. Stop. People's College of Medical Sciences and Research Center and another are questioning the order dated 13th January 2021 in one of the appeals. Stop. As the point that arises in all these appeals pertains to the validity of Rule 12, they were heard together. Stop. We have heard Mr. Neeraj Kishan Kaul, Learned Senior Counsel, Mr. Siddharth R. Gupta and Mr. Amal Pushp Shroti, Learned Counsel for the appellants, Mr. Saurabh Mishra, Learned Additional Advocate General for the State of Madhya Pradesh, assisted by Mr. Sunny Chaudhary, Advocate for the respondents. Stop. It was contended on behalf of the appellants that Rule 12 in an affront to their right of occupation, which is protected under Article 19 of the Constitution of India. Stop. Proscribing medical institutions from filing up seats which fall vacant due to candidates in the mop-up round not taking admission or candidates submitting resignation after taking admission amounts to an unreasonable restriction. Stop. It was asserted on behalf of the appellants that admissions made by them are on the basis of allotment of students for common counseling pool. Stop. After 2 rounds of counseling, unfilled seats are taken up in mop-up round. Stop. Such of those seats which are not filled up in mop-up round are filled through college level counseling as provided in Rule 13. Stop. It was further argued that the pronounced object with which Rule 12 has been introduced is to provide manipulations in the admission process and to prevent non-meritorious students from getting seats in better colleges. Stop. As the measures adopted have no nexus with the object according to the appellants, Rule 12 is violative of Article 14 of the Constitution of India. Stop. It was submitted on behalf of the appellants that Rule 12 results in some seats going vacant, which is not only a national waste of resources but also a huge financial burden to educational institutions. Stop. On the other hand, the state of Madhya Pradesh defended the judgment of the High Court. Stop. The state contended that it has become necessary to make amendment to Rule 12 and insert Sub-Rule 8 as it was found that students with lesser merit were getting admission to better colleges in stray vacancies which arose due to non-joining or resignation of candidates after mop-up round. Stop. Further, Rule 12 was also brought to prevent manipulation. Stop.